Hello everyone, this is the third time I'm doing this, so I'm very hopeful that this time you'll actually hear it. I wanted to give you a bit of a heads up with this assessment, which is not an assessment I'd describe as very, very easy. It actually requires you to bring quite a lot of your skills together, and you are fifth year students, so that's not unreasonable at this stage of your course. It is challenging, but hopefully it's also going to be enjoyable. At this stage you need to start thinking about which option you want to do, and by introducing you to some of the policy issues underlying the three options that I've given you, as well as giving you some leads on some sources to follow up, either names or actual articles, then I hope to give you some assistance with choosing one of those options. They do have different due dates, so think about that in relation to the rest of your timetable as well. So first of all, the first option that you're given in the course outline is an option about doing a law reform submission on information sharing between the family courts and family dispute resolution practitioners. Now, there was a recent reference to the Family Law Council, which is a council set up under the aegis of the Family Law Act to advise the government in relation to family law matters. And this was a broader terms of reference, but it encompasses this topic of information sharing between the family courts and family dispute resolution practitioners. And at the bottom of that terms of reference, which you can find on the internet for the Family Law Council, they speak about one of the sources that I would suggest you think about looking at. It's called Information Sharing in Family Law and Child Protection, Enhancing Collaboration, and it was written by Richard Chisholm. So the policy issues underlying this particular law reform submission and review are the issue of the fact that you now have a mandatory process of family dispute resolution prior to being able to file in the family courts, and traditionally dispute resolution or mediation was a consensual activity where the individuals could be reassured about the confidentiality of that process, and that reassurance about confidentiality, at least in our understanding of traditional mediation processes, meant that the parties could speak very freely about what was happening for them, and that increased the potential of being able to settle that matter at the point of family dispute resolution or mediation. So that is one particular value. The other value is the need for courts to have really good information upon which to make decisions about what is in the best interest of the child, as that is the paramount consideration for the court. So these two principles, confidentiality of information obtained through mediation and family dispute resolution, and the need for the courts to have good information, which often comes out in family dispute resolution about such things as violence that's occurred and possibly forms of child abuse other than family violence, then that is the tension we have, that need for information on one hand and the need for confidentiality of those processes, when those pre-court processes of mediation or family dispute resolution. So the other people who've written about that include Federal Circuit Court Judge Tom Altobelli and the Chief Justice of the Family Court, the Honourable Justice Diana Bryant. So the paper that they wrote, which can be found on the internet, was called "Has Confidentiality in Family Dispute Resolution Reached Its Use by Date?" So I think with those two sources you ought to be able to kick off and make a fairly good start on this submission, but don't leave it to just those sources. This is just an introduction to help you get started. So that is probably a narrower topic than the second topic, which I think is the broadest of the three, but also a very interesting topic and a very, very hot, controversial topic at the moment. So the second topic is about reforming Part 7 of the Family Law Act, which of course is the part that deals with parenting orders and children's matters. So there have been problems, particularly since 2006, with the complexity of the drafting in Part 7, and there's a number of different criticisms that have been made. These include the difficulty for practitioners of actually applying the legislation in such a way as to ensure a focus on the best interests of children. They include issues around the way in which the legislation is construed and whether the court can actually focus clearly on the best interests of children given the way in which the legislation is written up. And there are a lot of cases where appeal courts and various academic commentators have talked about the difficulty for judges at first instance just understanding the legislation and secondly applying it. So you can look at there are comments around the case law that focus on the complexity of the Act. So the third area that has been problematic has been the difficulty for members of the public of understanding the Act, given it's so complex, and the potential for misunderstanding the Act, and then, even if they're not actually in court, operating on a misunderstanding of what the Act actually says, for instance in relation to equal shared parental responsibility and shared parenting. So Richard Chisholm again has written in this area, and so has Helen Rhodes, that's RHOADS. Helen is the chair of the Family Law Council. So you could go looking for articles by those two, but there is a lot of information in this area. My suggestion, if you've got quite a broad topic like that, is that you're not obliged to deal with every issue that is raised by the particular topic, as long as the issue that you deal with is within that topic. So it is not unreasonable to say there are a lot of problems with this legislation, but the issue that I want to focus on in this submission is X, Y and Z, and I don't have space to deal with A, B and C. So that's one way to deal with that difficulty of the word length, and it is a challenging aspect of this assignment. The third topic is a fairly neat topic, and it's about the impact of family violence in relation to determinations of property disputes. So we have a fairly good understanding now that violence has very significant costs in our community. It's a very hot topic again at the moment. There's a Royal Commission in Victoria, and there's pressure on the federal government at the moment to consider some kind of a broader commission at the federal level into family violence. And we have had law reform, we have had an Australian Law Reform Commission report, a New South Wales Law Reform Commission report in 2010, and then a number of reports subsequent to that focusing on the impact of family violence in Australian society. So, but this is specifically about the fact of how family violence should be dealt with in the context of determinations of property disputes. So there is a particular case that's very important in this area, and there are questions about how consistently that is being applied through the case law, and there are questions about how family violence more generally ought to be dealt with in the context of property disputes. So there are even different dynamics, if you like, of property disputes where violence is an issue that could be considered in this particular law reform submission. So basically what I'm going to suggest you look at there is just starting with one article, and the article is a 2014 article in the Australian Journal of Family Law, and I have listed all the journals in the course outline if you want to go and have a look through some of the key journals in this area. And this article is called The Kennan Factor, and Kennan is the key case in this area, Issues of Indeterminacy and Floodgates. And this article is written by Patricia Esteal, E-A-S-T-E-A-L, and her colleagues. So I suggest you start there. Now I wanted to talk about the criteria briefly. You really need to focus on the criteria if you want to do well in this assessment, because I will mark strictly to it. That means that there'll be problems if your assignment is over 1,750 words, so it's a strict limit. And that doesn't include the footnotes, but you shouldn't be writing the body of your submission in your footnotes. That will also be a problem. So the criteria is set out fairly straightforwardly, I hope, for you. You are required to demonstrate a critical understanding of the operation of the law in the topic area, and that includes legislation, case law and procedures. So one of the issues is that if I'm not clear that you actually even understand the area of law, then you're not going to do well. In fact, you could fail that criteria. But if you've got a really good understanding, a really good grasp of what the law is and how it can be changed, and basically what you could actually do to change the law. You don't have to spell that out in great detail, but if you make it clear that you understand what needs to be done, then that's terrific, and that'll get you a good mark in relation to that criteria. The research is fairly straightforward. If you do very little of it and you get less than 3 key authoritative articles, then that will be inadequate. If most of your research is done on the internet and you're over-reliant when you are citing articles on 1 or 2 articles, that will also be towards a fail. whereas a collection of really high quality articles that you clearly understand very well and have synthesised will get you a very good mark. You need to focus on your ability to make a clear and succinct argument and to support your argument. You also need to show awareness of your policy, of the policy considerations in that particular area of law reform, and also of your own values. So if there's a very poor argument, it's not clearly structured, you're not showing much awareness of the policy issues or your own values, you won't do well. But if you show awareness of all of those things and you mount a very persuasive and well-written argument, then that is going to be up the high end of marks. The writing is key, because the writing is the medium through which you communicate your ideas, either persuasively or not persuasively. If your grammar is poor, your spelling is poor, your word usage is poor, and you haven't clearly revised and thought about presentation, then that's going to be a fail. So I would suggest, if you're not a good writer, this is one of those ones that you need to show to somebody else and get them to edit it, make some suggestions. Don't show it to another law student who's writing on the same topic, but show it to somebody who's not involved and see if they understand it, and use software to help you ensure that you're spelling properly and so on. If I read it and I read it from one end to the other and it's really straightforward and simple to follow and there's no need for revision, then you're going to get very good marks. Now, the referencing is very important. You need to be pedantic about this. That means if there are page references because you've quoted something, then you need to follow the rules that are in AGLC 3 in relation to all of their guidance around how to cite your sources. So if it's sloppy, it'll get poor marks on that criteria. If there is nothing further I could do, it's absolutely perfect, really, and there's very little, nothing I could improve on, then you're going to do very well. So what I would say is that the hard thing is meeting that word length of 1,750 words, but it can be done. I'm happy to answer questions if there are questions that are problematic for you. I'm happy to put them up on Blackboard and share that information for other people as well, because that will help them and that can be done anonymously. I'm also happy for you to put your own questions up, which I will answer on Blackboard. I'm happy for you to come to me with a basic outline if you're concerned that you may not be getting it right, may not be on the money in terms of the issue that you're dealing with, but I'm not happy to read the entire essay and tell you if it's good or not and where to change it so you can get a better mark. So that's probably pretty straightforward. Do feel free to email me if you've got questions about it. I hope it's one of those assessments that you find useful and valuable, but as somebody who's entering the legal system very soon, you need to be able to contribute to law reform in this area, and most of you are in 5th year and it's set at that standard. So I hope you make a start soon. Give yourself as much time as you can. The quality of the ideas and the writing is likely to be much higher if you try to give yourself time to think about it, so a month or so at least. Don't try and do it in the last week. You won't come up with something that is nearly as good as you could come up with. Okay, good luck with it, and yeah, make contact if you need to.